Can I know if I'm audible?
Can you hear me?
Yes.
Yes, ma'am. Audible.
Okay.
Yes, ma'am.
So I think
Yes,
we'll start
ma'am,
off.
you are audible.
I think we'll start off. Uh, Good evening, one and all. A hearty welcome from the Internal Quality Assurance Cell of Srinarayana Law College, Potota, Ernakulam. I am Tanya Tom, the student coordinator of the IQAC cell, and I'm very happy to be hosting this webinar. Let me start off with a few instructions. To avoid any sort of interruption during the session, please make sure to mute yourself. A gentle reminder that any disruption of the webinar will cause your removal. Also, kindly use the chat box to post your questions and while the session is on. And as said earlier, it will be answered individually at the end of the webinar during the question and answer session. To save time, we will be putting your individual questions at the end of the session, and e-certificates will be provided upon feedback submission, and the feedback forms will be put up in the chat box. Kindly ensure to stay till the end of the session and use the link and give us your feedback. Only then you will receive the certificate, and you will receive it within a period of 10 days. I now invite Ms. Ashwini Ujjwal, our very vibrant coordinator, faculty coordinator, to welcome the gathering. Over to you, ma'am.
Thank you, Tanya. A very good evening to one and all. It gives me immense pleasure to extend a warm welcome on behalf of the Internal Quality Assurance Cell of Sri Narayana Law College, Putota, conducting this international webinar on drafting of wills, scripts, and traps by our esteemed guest and resource person for today's session, Mrs. Jaya Jayadev, who is a solicitor working with Mora Donnelly & Co. Solicitors, Dublin, Ireland. She has got more than 16 years of practice in Ireland. Over these years, she has specialized in dealing with conveyance, will, and probate. She did graduation at Bangalore University and has also got a teaching experience more than 3 years in Bangalore University. Thank you, ma'am. Now, I proudly welcome our beloved principal, Professor Raghu, sir. I'd like to thank her for constant effort in such a valuable event. Others would have been welcome. To welcome Mr. Ajay, ma'am. Sindhu Sri Priyanka Prasad, coordinator of IQAC, and all other faculty members who have shared immense support through the coordination of events. I also welcome and all other participants who have mission. Thank you. And now will be proving and
Ma'am, your voice is breaking.
Sorry. So, this is and I welcome you all to this session. Good luck. Thank you.
Thank you, ma'am. It gives me, yes. Thank you, ma'am. It gives me great pleasure to invite our principal, Professor Dr. Raghunathan KR, whose efforts have been tremendous to enable our college to host and attend innumerable webinars, and most particularly the first ever international webinar. And I invite you to address the gathering, sir. Over to you. Sorry, on mute. Sir, hello. Sir, Can the participants hear us? Is there any technical issue? Can you hear us?
Yes, Tanya, you are audible.
Yes.
Yes, Tanya, you are audible.
Okay.
Uh,
Principal, sir?
Sir, I think sir
Is sir in the meeting?
was the.
He was in the meeting. Maybe he lost his connection.
Maybe. So,
I think he's muted. Degu sir is muted.
Okay.
sir is muted. Okay. Participants,
Please tell him to unmute.
Yes, yes.
Sure, sir. Thank you. Tanya, are you connecting to principal, sir?
Yes, ma'am.
Okay. Thank you.
Participants, I apologize. Please wait. Ma'am, unfortunately, I'm not able to reach him. He's not picking up the calls.
Okay. Okay, Tanya, you may please invite Jaya ma'am to start the session.
I think we'll invite sir at the end of the session to
Yes.
talk to the gathering. Okay. Okay.
Okay.
Dear participants, I apologize. I now request our dearest resource person, Jaya ma'am, to continue with this webinar, with the session that we have all been waiting for curiously. Thanks a lot, ma'am.
Okay, thank you for your kind introduction, and I'm grateful to Dr. Raghunandan.
As in the audio. Sorry, Jay, one audio problem. That's why.
Okay, no worries.
Okay, that's a part and parcel of the webinars.
Okay.
So I request you to kindly address the gathering, maybe a few words.
Okay, now yes,
Sir, we can't hear you. We can't hear you.
Can you repeat?
Sir, I request you to address the gathering.
Okay. So our resource person, Srimati Jaya Jaydev, is an expert in this field who is well versed in Indian law and British law. She is currently working in a legal firm in Ireland, and I am honored to have been her batchmate for our LLB course. This webinar will surely provoke your thoughts and intellectually stimulate your mind. So attend the webinar, understand the essentials of the will and clarify your doubts, and start to draft your own will and help others to draft their will. Thank you.
Thanks a lot, sir. Ma'am, now we can start with the session. Over to you, ma'am.
Okay, thank you. Good afternoon to everyone, and thanks all for your giving me this opportunity. I am grateful to Dr. Raghunandan and Principal of SN Law College for providing me this great opportunity, and thank you all the organizers behind this for the time and effort in organizing this function. Anyway, I have immense pleasure in talking on this topic because It's one of the relevant area in Kerala, because I have seen that people are reluctant to draft wills in India, thinking that, or especially in Kerala, thinking that let the property be distributed as per law. So I think it's a very relevant topic for Kerala, and I will start with my presentation and hope it will be helpful for the future generation to encourage them to draft will in future. So I'll share my screen with you, and I'll show my presentation.
Okay, ma'am.
Can you see my screen?
It is not yet.
No, it's not coming up, isn't it?
Yes,
No,
ma'am,
no,
we can
ma'am.
see
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Yes,
Yes,
ma'am, we can
Yes,
see.
yes, yes.
yes, we can
It's
see it.
coming.
that we can.
Okay. I can't see any. Okay. So, so why do you need a will? That's maybe the question that may be popping up your mind all the time. Do I need to write a will or not? When there is a law that dictates the devolution of my property after my death, why should I bother to write a will? Look at how a person's estate will be distributed after his death. There are two types of succession. First one is the testamentary succession, if a person is dying without leaving a will. And the second one is the testamentary succession, leaving a valid will. I'm stressing the point valid will, because if a will is some way it is not valid, then there will be testamentary succession will change back to intestate succession, or there will be a partial testamentary succession and partial intestate succession. So leaving a valid will is most important to have a proper testamentary or full testamentary succession. So we first look at the testamentary succession. First look at the intestate succession. That means leaving no will. So that is governed by the mainly three acts, that is Indian Succession Act and Hindu Succession Act and Muslim law. And if a person marries under Special Marriage Act, then his personal law has no relevance in relation to the distribution of his assets after his death. That will be the Indian Succession Act that will be governing the distribution of the assets after that person's death. So look at the heirs. So there are laws actually applicable to the distribution of your assets after your death. But look at the heirs under each of these acts. Look at the Indian Succession Act. Who are the heirs under Indian Succession Act? It will be widow will be getting 1/3, and the 2/3 will be to the linear descendants. And if there is no linear descendants, half will be to the widow and the rest to be the kindred. So look at that. Who are the heirs? Wife, descendants. Then in the absence of linear descendants, it will be kindreds. Then look at the Hindu Marriage Act. In the case of a female, who are the heirs? Husband, children, all will be getting shares. And in the case of a male, who are the heirs? Wife, mother, and the children. So everything is scattered and provided in the law. Then if you want someone else to be added in the list of heirs or not, that is the most important question to be asked. If you are happy with the heirs, you will think that you don't have to write a will. If you want to give you a portion of your asset, or you want to give a share to a third person who is not of your immediate family, but someone you have an obligation to look after your death, or who has served all entire life for you, and you think that you should be providing some financial support after your death to that person. Of course, you can give instructions to your children or heirs that this you should be giving this share or this much of my property to that third person, even though he is not the person that coming up as a heir in the as per the law. But there is no guarantee that your children will be fulfilling your intention or wishes after your death. So if you want your intention of wishes to be fulfilled after your death, the only way to do that is writing a will. So to protect your loved ones or the person who cared you, is in the best way it is to write a will. Then the next one is to protect your asset in the best way. So if you don't have a will, what will happen to your estate? It will be distributed among all the heirs in the standard way as defined by the law. Is that what you want? you want to give someone extra support by financial, or if you want to think that, if you think that some person can manage this asset much better than the other here, so should I give this asset to that particular person? For example, look at Ambani's case. In what happened on the death of Ambani, he didn't leave a will at that time. And what happened to his asset? It was divided between Anil Ambani and Mukesh Ambani in equal way. That's a fair deal between the children. Everybody is happy with that one. What happened to Anil Ambani? Got the telecom sector and all. See, Mukesh Ambani now started Jio and all. That is now market leader. So look at Anil Ambani. What happened to him? He ended up in the civil suits in UK court and fighting for the bankruptcy case and all. What about Mukesh Ambani? He's capturing all the markets, and he's now the market leader of Jio and telecom communication and so on. So if you distribute your asset to your heirs, look at the heirs' capacity and abilities, and see whether this person can manage, whether he can make some benefit out of that particular specific asset, is the first question to be asked before deciding how the share to be distributed between the people. If you have agriculture or share or cryptocurrency, that is the new trend in the market, to invest in the cryptocurrency and all the stuff. So look at the persons, whether they are capable of managing the asset. When you buy all these assets, what is your intention? To make money out of that asset and grow that business and become the leader or the top person in that area. So that is your intention. So what should happen after your death? You want the heirs to continue that and make money, profit, and everything from that. So look at the person's or heirs' capacity and ability and decide to whom I should give this asset. Even you have agricultural land. If you have one of your children has no interest in the agricultural land, what's the point in giving him that agricultural land? Give to the other person who has so much interest and enthusiasm in agriculture. Then in the case of share, someone is so expert in share trading and all, give that asset to the share person who is interested in that. That will be beneficial for him and he can grow that asset. So look at your asset in that perspective and decide to whom I should give this asset. Then especially in the case of shares, if you think that, that can be distributed between my heirs inequally, before taking any such decision, make inquiries with the relevant dealers or authorities to find out whether shares can be divided equally or not. Because of demat and all the stuff, it may not be sometimes easy or possible to give two people the same share in a company or something. So think about that and see, okay, maybe I can give one person share in one company and the share in another company. So that will make administration much more easier. So look at all these aspects and decide to whom I should give, rather than leaving it into the hands of the law. Then if you have any jewelry or something, or some valuable movable properties or something like watch or gold, diamonds or something, you may have particular person in mind to whom you want to inherit that property. So put it in writing by drafting a will. Maybe your intention, you might have communicated to your children or heirs, but there's no guarantee that will be fulfilled after your death. They won't even care, or maybe they might just compromise and say that, anyway, that's my sibling, so let them take it and all. So think about all these things and decide whether I should leave it in the hands of the law, or should I dictate how my asset to be distributed after my death by myself. So that is the question to be asked by yourself. Then the other is if you have a will, administration will be so easy. Otherwise, there can be fighting or row between the family members on the assets and all. If there, and even for tracing legal heirs, if it is small family like husband, wife, and children, it's a small family, happy family. On the death of one person, the other person will be getting the share. That's fine. But think about a family who doesn't have immediate family like spouse or children. What will happen to the estate? It will be distributed between the siblings or children. If one of the siblings is passed away, then their children, and so there will be different line of heirs who will be inheriting the property. And think about some of your siblings have gone to US or Australia or some other foreign countries, they settled down there, and you have no contact with them at all. So the administrator may have the difficulty of tracing that heirs and putting them into the list of heirs, and then getting all the property distributed to all these people. So that will all delay the administration process and will leave a huge burden on the administrator to distribute the property, and it will even those frustrating for the heirs who are actually present there and who are willing to take that asset. Then also think about people who are around you, who are supporting you, and instead of giving your share to someone who has gone away from the country and settled in some foreign countries and who has not even cared for you, what's the point in giving them a share in your in your estate? Why don't you give the share to the person who is living next to you? So think about all these things. I had a case in which a 87-year-old man passed away without any spouse or children. He had brothers, but some of the brothers had left Ireland and settled in Scotland. He joined in the Scottish Army, then married a Scottish lady, and then they have children and all. So one of the brothers approached us to administer the estate and all. So we had the difficulty of tracing the children of that sibling who left Ireland and settled in Scotland. He actually passed away. So we don't know whether the wife is still surviving, whether children are surviving. We have no clue. Only thing, he has some last correspondence a few years back. So that we had the difficulty of writing to the local post office and to the address last known and all. Then we couldn't get any information about that heirs. So then in Ireland we have a provision to set aside that particular share in a different account and wait for 7 years. So there is a presumption that if a person is not known for 7 years, the presumption of death is there. So after 7 years, we can deal with that share and distribute it to the other heirs. So all these formalities and all has actually delayed the administration process and frustrated the other heirs and all. So this is one of the things you have to think about without living with. If you are not writing a will, why don't you make the administration much more easier by drafting a will? Then the other thing, if you have assets in other countries, inheritance tax is a main issue. In India, there is no inheritance tax at all. But in foreign countries, there is inheritance tax, not for the spouses, but for the children. So you can plan for that inheritance tax if you have assets in a foreign country by taking instructions from the lawyer and drafting the will. And even the insurance company, if you want to avoid insurance tax, you can take after advice from the lawyer. You can even give the share to children and grandchildren and all. Of course, nobody wants to give huge lump sum amount to grandchildren, but you can take advice in that aspect and write a will. And even you can give the instructions to the lawyer to take instruction from the lawyer how to avoid inheritance tax, because there are insurance policies to cover the inheritance tax in Ireland and all. So you can take an insurance policy, and then the legal will not have to pay the inheritance tax from the asset they are inheriting from the estate. That insurance company will be paying that. So all these are there. If you plan your estate succession and if you properly draft a will, all this will be covered in the administration of the estate. So in considering all these things, I think it is a better way to protect your then. Then we'll look at what is a will? It's a written document or testament by which a person describes how his estate and wealth has to be distributed among the descendants. And except for Muslims, for all other persons, Indian Succession Act 1925 is the act that dictates the writing of a will and the formalities and the execution and the administration of the estate. If we look at the Muslim law, they have two important schools of thought, that is Shia law and Sunni law. And if a Muslim person marries under the Special Marriage Act, again, there's a personal law has no role in the distribution of the assets of that Muslim. It would be the Indian Succession Act which would be applicable to that person. And there are only main conditions which are same as the Indian Succession Act. That person should be of sound mind, not a minor, and the will is not made under coercion, under influence or fraud. Then even under the Shia law and the Sunni law, there are different. There are some restrictions for a Muslim to dispose of the property under the will. They can dispose of the property under the will only 1/3 of the net estate. Why I am using the word net is that After discharging all the debts and liabilities, what is left over? Only 1/3 of that they can dispose by will. The rest has to be distributed among the heirs as per the Muslim law. But in the case of a Shia law, they can distribute 1/3 of the net estate to the heirs without the consent of the other heirs. But Sunni law, even if 1/3 is given to the heirs, they have to get the consent of the other heirs, because that heir is placed in a higher financial position than the other heirs. So the consent is required. Under both the laws, if the share is more than 1/3 of the net estate of the deceased, then they have to get the consent of the other heirs. Then there are some conditions as well as the legatee, who is going to get the benefit. It can be Muslim or non-Muslim, but in the case of a non-Muslim, that person should not be against Islam. Then the beneficiaries can be institutions or charity, but there also the same principle is applicable, that institution or charity should not be promoting any activities other than Muslim. Now we look at what are the assets to be included in the will. Firstly, I'll concentrate on the joint property held by the deceased and other person. There is, as you all know, there are two concepts when two persons hold the property: joint tenancy and the tenancy in common. Most of the couple, they may be holding the property as joint tenants. That means each person has 50% of undivided share in that property. They will have 50% of divided share only on the death of that person. In the case of a joint property held in jointly as joint tenants, on the death of one person, the other person is automatically inherits the whole property, and he has the full ownership of that property. That's the situation. So, as per Irish law, we never include joint property in the will, because it automatically goes to the other person. But I'm a little bit concerned about the joint property in India, because I couldn't see any particular law in that aspect in India. Suppose if two persons who are holding the property in the joint names, like suppose A and B, couple or whoever it may be, A and B, they are the joint owners of a property. Both of them die in a car accident or a plane crash or in some other calamity. What will happen to the property? Who will be inheriting the property? How can you decide who died first? There is a clear-cut provision in Irish law which says that if two persons die in a circumstance rendering it uncertain to decide who died first, then the presumption is that both of them died at the same time. That means simultaneously. So that means that there is a severance of tenancy in that case. Each person will 50% share be divided between those two parties. So each person will have 50% share in that property. A and B are the joint holders. A will have 50% of share in that property, and B will have 50% of share in that property. So the heirs can inherit that property, B's heirs can inherit that property. If the heirs of both the parties are A and B are same, there is no issue. But if the heirs of A and B are different, and there is no will, as per if you look at the heirs list in Hindu marriage and all, maybe the heirs may be different. So then the fighting and confusion can arise, and that can lead to litigation. So that is why I think joint property should be included in the will of an Indian person, and you can make a clear-cut provision statement or mention that in the will, that this property is held by both of us, and in the case of its simultaneous death, or if one doesn't one predeceases the other, or one dies within a short span, maybe 1 month or something. When you look at the draft examples I put later on, you will understand how you will get an idea how to draft that wording. Put it in like not survive me within 1 month or something, then that property will be going to such a person. It's a good idea to include the joint property in the will. That is my suggestion. Anyway, as an assignment to the students who are watching this one, they can look into the law and see whether there is any clear-cut provision which help you to determine who died first in the case of a simultaneous death. I have two cases in that case. That is the one I have it in the slide. Madampat Rohini, others, and Devi and others. In that case, there was the question was who died first. The plaintiff was the Vasudevan's wife. She was claiming her share in Vasudevan's property. Actually, this Vasudevan has left the country and went to Ceylon long back. And the property was held by Kalyani, Vasudevan's mother and brother Achyutan. And there was clear evidence that Kalyani predeceased Achyutan. So Achyutan got the property in his own name. And the question is whether Vasudevan died before or after Achyutan. That is the question. If Vasudevan died after Achyutan, then Vasudevan will be getting the share and his wife can get that share after the death of Vasudevan. So that is what the argument of Vasudevan's wife. But Vasudevan was not known for a few years. So the question was, from which date he is not known for these people. So the lower court applied, there's a clause section in Hindu Succession Act, which is section 21 of the Hindu Succession Act, which deals with the presumption in the case of simultaneous death. In that act, which specifically says that until the contrary is proved, that the younger survived the elder. So in this case, the lower court took the decision that Achyutan being younger, he survived, Vasudevan being younger, survived Achyutan and gave his property to wife. Then the other parties appealed, and anyway, upper court overruled that decision and said that this act is not apt provision to apply in this situation because section 21 of the Hindu Succession is applicable only in the case of circumstances in which it is uncertain to decide who died or who survived the other, and that is applicable in the case of normal calamities or accidents or something, and not in this case. So that is the other case in Padavam Raja Shetty versus Ganathan. In that case also, Padavattamma and Janava are the two people, and Padavattamma had children, the son, but she was taking care of her brother's daughter Janava, and she prepared a will in disposing all his property to Janava. And on a night, both Janava and Padavattamma, both of them died on the same night. So the son challenged the will and said that he has to inherit the property. So the question before the court was who died first. Both of them died on the night. In that case, the court applied section 21 of the Hindu Succession Act and Succession Act in that case and said that Janava survived the Padavattamma. So in that case, Janavamma got the property, and after her death, her heirs would have inherited that property, not the son of Padavattamma. So simultaneous death is very crucial in the case of joint property. So I think you should be including the joint property in the assets while drafting the will. Then the other point is the joint bank account. Normally in India, joint accounts means if it is between the spouses, it's fine. After the death of one person, the other can inherit the property. There won't be any issue at all. If you open a bank account in the name of your children, or someone has a bank account between mother and son, or father and daughter, or whoever it may be, what will happen to the account after the death of one person? Maybe especially the father or mother. Whether the son or the daughter has the right to use that money as her own, or whether that money will be going to this son or not. That's the question to be considered while drafting the will, whether this should be included in the will. In a case in England, that is Northern, I have mentioned it in my slides. In that case, mother sold her property and put that into the bank account in the joint names of herself and her son, just for the administration purpose, because then my son can manage that bank account and all. Then after the death of mother, what happened? He just transferred the whole funds to his account, joint account with his wife. Then the other heirs of the mother challenged that act and said that should form part of the estate, and court held that should be part of the joint estate, because part of the estate of the deceased, because the mother has no intention to give that money to the son. That account was opened only for the purpose of administration or management and not with the intention to inherit, to give that property to the son. So the most of the banks, when they open the account, they might ask the main account holder to find out what is his intention if something happens to that person, whether it should be given to the other person or whether it should be given to the heirs or not. But as far as the bank is concerned, when that property is given to when that funds in that account is given to the joint account holder, their responsibility is over. But the question is whether that should form part of the estate or not is the other question. So my advice is that should be included in the will, and if the intention of the testator is that after his death the joint account holder can inherit that, let it be mentioned in the will itself, so that can avoid future confusion and disputes between the other family members. Then the other thing is the nominee to the accounts. In India, that's a practice that for every financial institution, when you open an account or when you invest any sort of money there, they will be asking you to complete the nomination form. And you will be putting someone's name, maybe your children or someone's name as a nominee in that account. But in Ireland, there is no such practice at all. We never have any nominee in any of our accounts, save for the credit union. And that also, even though we give someone as a nominee in the credit union, only up to 30,000 the nominee can take money as their own, and if it is more than 30,000, then it will form part of the estate of the deceased. So if there is a nominee in India, even the bank's responsibility is over. When that money is given to the nominee, bank is happy, oh, I have given that money to nominee. Then the question is whether nominee can hold on to the money as his own property, or should he be putting that money into this as a part of the estate of the deceased and should be distributing that into the between the heirs. So nominee has no right at all, actually, as per law. Nominee has no right over that property. It should form part of the estate of the deceased. But normal misconception among the people is that they think that nominee is the beneficial owner of that property. So people may omit to include that in the will. So as a lawyer, when you are taking instructions from your client, you should be very specific about all these assets and find out whether the client is having any of these type of assets and what is his intention what is his intention after his death, how these properties or assets should be distributed after his death. Most of the clients, they are not aware of all the things, and you are the right person to ask the question to get the right answer from them. So it is your responsibility to get the right answer by asking the proper questions to them. So these are the three assets I think should be included in the will. Then comes the foreign asset. If a person dies leaving assets in different countries or different jurisdictions, he is said to have cross-border estate. So then the question comes, which law is applicable to that estate, whether Indian law is applicable or the foreign law is applicable. I'll just take an example because it's a very complicated area, whether which law is applicable, because some of the countries apply the lex domicile and some of the countries will apply the law of the country where the property is situated, and some of the country will apply the rule of habitual residence, and some country will apply the rule of nationality of that person. Especially France has they will apply the law of habitual residence in the case of distribution of assets and all. But but some of the countries that is called systematic countries, and there is other countries called Unitarian countries. In the case of Unitarian countries, they have the same law applicable for both movable and immovable. So in all these foreign countries, even in India, there's a strict distinction between movable and immovable property in the case of administration of the estate. I have the slides next. So if you are looking at the domicile of a person, there are three types of domicile: domicile of origin, domicile acquired, domicile of choice, or domicile of dependency. That means origin and acquired and all, everybody knows that origin is by birth and acquired is acquired after taking up a habitual fixed habitation in another country and all. So domicile of dependency, that is the case of a married woman. If a married woman marries a person of a different domicile, then her domicile changes to the domicile of the husband. So this law is up. This is the Indian law as well, but most of the countries, they change the and can cancel the domicile of dependency. Especially in Ireland, there is this. They were following the law of dependency until the passing of the Domicile and Recognition of Foreign Divorce Act 1986. Yeah, after that, there is no domicile of dependency. Wife can retain her domicile even after the marriage. But English law also, they abolished the system of domicile of dependency, but only for the marriages that has happened after 1974. So the question will come, when the question comes up in a foreign court to decide the domicile of that person, they will be applying the domestic law to determine the domicile of that particular person. So if English court is deciding the domicile of a person, and if that female has married before 1974, her domicile will be that of the husband. And if the marriage is after 1974, then the domicile will be that of her origin or choice. So all these domestic laws differs from country to country or country to country. So that is all will be relevant for if you are having foreign assets in other country. So the first thing I will deal with the will and will. If you have a will dealing with the foreign assets, things may be much more easier, because most of the courts will accept the certified copy of a probate granted by the country of either the nationality or domicile or the habitual residence or the place where the property is situated. So if a person, I will take an example of Ireland and India. If a person of Indian domicile, we'll see if we don't know, but India also has a clause or provision in the Indian Succession Act saying that if a person domicile cannot be decided or is not uncertain, then he is presumed to have the Indian domicile if he has the domicile of origin as India, because even though he has taken another nationality or something. So if he has the will in any other countries, Irish courts will accept that certified copy of the probate, because in most of the Western countries, the financial institutions will not release the assets to a personal representative or the executor without actually having the proper grant of probate. And India, especially in Kerala, I haven't seen that practice of extracting the grant of probate. But if you have foreign assets, definitely you should need a grant of probate extracted from that particular country where the will is made. If there is no will, I'll come to that area later on. So if you have a will in any other place, you have to get a grant of probate from that particular place and certified by the Department of Foreign Postal has to be impressed on that by the Department of Foreign Affairs of that country, and you can place it before the financial institution. Some of the financial institutions may release the funds to the personal representative on the evidence of on the production of a will or some will, if the amount is of a nominal amount. But they may look for an indemnity, and at the same time, they might even copper fast in that they may ask for an insurance policy as well. But in the case of if there is a will, it will be, things are much easier. But definitely they'll be looking for a capital gains acquisition, capital gain clearance certificates, clearance saying that there is no liabilities due on that estate from the deceased persons or for the beneficiary. So in relation to inheritance tax, for most of the Western countries are very strict about paying the inheritance tax, and they won't release the funds until and unless you have a certificate of clearance from the revenue. One of the main procedure in getting a grant of probate is to submit a form called CA24 that has recently changed to a different form. Now everything can be done online to the revenue. So we have to submit to the revenue all the details of the assets of that particular deceased person and who are the beneficiaries and what are they going to get under that administration of the estate. All the detail has to be submitted to the revenue, and revenue will review that and they will issue an acknowledgement. Previously they will send back the form. Now the system has changed and everything can be done online. Then we will get an acknowledgement of that thing, acknowledgement of that submission. Then if you are when we have to print it and submit that acknowledgement along with our probate application to the probate office to get the grant of probate. So it's very difficult to get the assets released from Ireland without all these formalities. Even though you have a will done in a foreign country or something, all these formalities has to be complied with to get a grant of probate in Ireland. Then just one more thing I just want to mention is that in the case of a non-resident personal representative of a deceased person, there's a strict rule that they should appoint a lawyer in Ireland as an agent of them for the administration of estate, just for the purpose of capital gain and inheritance tax, because then that agent will be responsible and liable for the payment of inheritance tax in Ireland. So all these are the complications. And if you have a will drafted in India and you don't have any clue about all these things, it will make things much more difficult for the administrator to manage all these things. So my request or my advice is, it is better to exclude the foreign assets from the will drafted in India and have a separate foreign will in that particular country where the property is situated. So that is the case in relation to if you have a will. If you don't have a will, how that property can be get released? As I told you earlier, you can approach the financial institution and tell them and approach them and ask them the requirements to release the funds. The same way, if you don't have the will, it is not that easy to get the release. So you definitely have to get a probate granted from the Irish office or the foreign of probate office to keep the ball moving. So the first step for that is to get so then the property will be distinguished between movable and immovable property. So if the immovable property is located in one country, it is depending on the law, depending upon the law of that country, the domestic law will decide whether it should follow the doctrine of lex domicile or the nationality of the person or the habitual residence, or what way it has to be decided. So if you look at the Scotland, the movable property is lex domicile. So they will be asking from the person to bring the affidavit stating that person's entitlement to apply for the probate of grant, and that should be done by a practicing lawyer of that particular country where the person's domicile is. And then if you submit that with that affidavit should state his entitlement and set the law by which that person is entitled. If all these documents are submitted, then a grant of probate for the administration of the movable property will be issued. Then what about the immovable property? Most of the countries have the principle that immovable property will be governed by the law of the country where the property is situated. But that also sometimes it's different to different countries. In France, it is habitual residence, and in Denmark, it's also habitual residence. But in the case of Ireland, it's a law of the country where the property is situated. So it is as per the law of the country. All these are for the formality of getting the grant issued. Once the grant of probate is issued, then again all these questions have to be raised again. Which law is applicable in the case of distribution of movable property and distribution of immovable property? The first thing is to find out the law that is applicable to comply with the formalities of getting the grant of probate. So two situations are there. First, complying with the formalities of getting the grant of probate issued from that particular country where the movable or immovable property is situated, and then find out the law that is applicable to get the asset actually released from that country by applying the relevant law. So once the grant of probate is issued, then you have the grant of probate from that particular country. Then they will look at the assets. There's an immovable property and movable property for that person. So how this movable property can be movable property can be distributed. Then they will look at the domicile of that person. In the case of Scotland, Ireland, UK, and all. But in the case of France, Spain, Denmark, and all, it is the habitual resident. For the Spain, it's the nationality of that person. Then then the doctrine of renvoi comes into play. They will refer the matter to the other country to decide how that property should be, how that movable property to be distributed to the heirs. So then doctrine of renvoi, single renvoi, double renvoi, all that things, they will send back the matter saying that if they have a different role, if it is if for example, if the person has an immovable property in Ireland, and the person is movable property in Ireland, and the person's domicile has to be first decided to determine which law is applicable. If it is decided that he is of domicile of India, then the matter will be referred back to India, and India, the same law is applicable. Movable properties governs the law of domicile of that person. So it's fine for India will take that matter, and they will decide how to distribute the assets. So that, but if it is gone to France, what they will do is that they will see where is the habitual residence of that particular person, and that matter will be referred back to that country, and then that country, depending upon whether they accept the doctrine of renvoi or not, they will either send back or they will decide that one. So these are all the complications in the case of movable properties. In the case of immovable properties, a bit more easy, because most of the Western countries, they follow the law of law of the country where the property is situated. But in that case, you have to just think, watch out for some restrictions that are in place in different countries. The first one is forced heirship. Just in Ireland as well, there's a forced heirship thing. That means, I'll show you that's yes. A forced heirship is the term used when a state provides that a specified person have automatic rights to the succession of a portion of the deceased estate. So in Ireland, if there is a will, and will provides a provision for wife, then the wife has the right to either to accept that benefit under the will, depending upon the amount or the value of that benefit, or can go for a legal right. As per the Irish Succession Act, a wife has a legal right to 1/3 of the share of the husband's estate. So she can elect whether she wants to get that 1/3 as per the legal right, or she wants to go with the will. So in the case of Spain, there is another condition that 2/3 of actually a person can dispose of the estate, dispose of his estate more than 1/3. Only because 2/3 has to go to the forced heirs. So if he has made a will disposing all of his property, it is invalid as far as 2/3 is concerned. So that's why we are saying that you should be taking legal advice from that particular state where the property is situated. Then in the case of France, they have only freedom to dispose the property, only a portion of the asset can be disposed by will, because a certain portion of the property has to be distributed as per the law. That will automatically be distributed as per law to the heirs as per the law. And England, they have the full freedom to dispose of the property by will. But what will happen that if their descendants think that they have not been provided properly under the will, then they can challenge the will. So it is better to take legal advice from that law, from that country, before drafting a will. If there is no will, then it will be the law of that country which will be dictating the inheritance of your property, not the law of your domicile or not the law of India. If you have properties left in some European countries or other countries, it will be the law of that country who will be dictating the distribution of your immovable property, not movable property. Movable property, sometimes the law of country will say that it's a law of the domicile. So it can come back to India. So it all depends upon the particular domestic law of that particular country. Then there are some countries have a matrimonial regime. That means if a person acquires some property after the marriage, then there is a concept of community rights, community property. That's called community property. That means that Even the spouse, irrespective of whose name that property is held, both husband and wife has equal right of that property, and that they cannot dispose of that property under a will. So if a person writes a will in India, including all these properties, and if he has to enforce that will in a foreign country, they will look at this matrimonial regime and see if he has dealt with this property in the will, then that benefit, that bequest will be invalid as per their law. So before drafting a will, it is better to find out the law that is prevalent in the country where the property is situated. Then the next one is the foreign divorces. If a person drafts a will in other country, and he includes all the property as per his wish and all in the will, then if you want to implement that instructions in another country, and the question is whether they will accept the foreign divorces or not, and you haven't even provided any provisions in the will for your divorced wife. As far as you are concerned, the wife is divorced. But if the foreign divorce is not accepted in that country, then they will not, that divorced wife is still a spouse for the purpose of inheritance rights and for the purpose of inheritance, and she will be entitled to, if it is in Ireland, she will be entitled to 1/3 of her legal right under the law. So the first thing, there is a provision in Ireland, you can get a declaration from Ireland accepting the foreign divorce as valid in Ireland. So if you have a divorce granted in India or something, and you have properties in Ireland, it is better to go through that route and get the declaration from Ireland, recognizing that validity of that foreign divorce in Ireland or in other, depending upon the other countries, so that if you write a will excluding the divorced wife, then that can be implemented in the foreign countries. So that is the other point to be remembered when you have the foreign assets. Now we'll look at the there are two types of wills, privileged and unprivileged wills. Privileged will means if a soldier or someone who is just going for a war or something like that, they can just write a will orally or something, just if they're going to take the risk, and also it's just for the convenience, that is called privileged will. Unprivileged will is the proper will done by all the normal persons. So under section 57 of the Succession Act clearly states that how to make a will. So we have discussed what are the properties can be included in the will and all. Now we look at the formalities of a will. It's as I told you in the Muslim law, this is almost similar to the Muslim law or other thing. It should not be a minor, it should be a sound mind, and it should not be done by fraud, coercion, or importunity. And if you look at if you do a survey of the cases pending in the civil courts, and you can see that a lot of cases are in the civil lawsuits are based on the family law disputes and partition suits and all. And even you can see cases, cases I listed in this PPT, you can see the cases which are relevant even if there is a will, because the people will be contesting the validity of a will, if saying that it is with undue influence, and or maybe there may be some flaws or mistakes in the will. So all these wills can be challenged in the court. So you have to be very careful while drafting a will for a third person to make sure that it is done properly and it will never be contested in the court. So when a person engages lawyer for a criminal act or criminal case or something, what that he is expecting from this lawyer, that he will be saved from the punishment of that crime. In the same way, if a person entrusting you with a will, drafting a will, you have a responsibility to that person to make sure that this will never be contested in the court of law. So that is the point where you have to concentrate and make sure that will is without any mistake, and you won't give any chance to get that will contested in the court. It's a craft actually, drafting a will. Then the other thing, how to execute, how to witness the will, and how to attest the will, and what are the attestation clause and everything. One of the main condition is that there should be two witnesses to the will, and two witnesses should be present with the testator at the time of signing the will. That is the most important thing. 3 of them should be present while the testator signs the will. When the witness signs the will, it is not necessary that the other witness should be present. But when the testator signs the will, two witnesses and the testator should be present at that time. Three of them should be present in the room, and then testator signs, and the other people then has to sign in front of the testator. So these are the most important conditions for the attestation clause. Even though there is not particular form of attestation, these formalities has to be complied with. Those are the cases I have referred in where the wills were contested on the basis of either pure attestation or there is no executor appointed in a case in the will, or all these wills were contested on one or the other grounds. So then we will go to the drafting of the wills and see how to draft a will. So first clause is the most important clause in the will. It should give the details of the testator, his name, age, because it should have all the information to identify the testator. And then the other thing is, next thing is the revocation clause. It should revoke all the previous wills and testamentary disposition. In this place, you have to be very careful not to revoke any wills made in a foreign country. So it is better to have a specific sentence saying that it is not revoking any will or testament disposition made by that person in a foreign country. Then if you want, you can just mention that I am of free, it is made by free of coercion and all this stuff. So you can look at the draft. I have 3 examples I have given in the next PPT. In the first one is the details of the person, and then he revoking the other previous. The second one I have mentioned that he is revoking only the previous testamentary disposition made in India and excluding any testamentary disposition made in a foreign country. So that way this will not revoke any foreign wills. So that is very important. If you have a client with foreign assets and he has made any wills or he is intending to make any wills, it is better to make it clear that this will is applicable only to India unless you have instructions differently from the client. Then the other thing, as I mentioned when I was talking about the foreign assets and all, one of the questions to be asked is the domicile of a person. If he has gone to foreign countries and settled there and have permanent home in that country, the question will come up, where is this person's domicile? What is this person's domicile? He is an Indian domicile or not? Most of the people for convenience say that Indian domicile. Even we all say that Indian domicile to avoid some tax or something and also. But actually what is his law of domicile? That is a little bit difficult to ascertain, because only one person can say what is his domicile. So maybe if he has foreign assets and all, and he has a different nationality or different citizenship and all, maybe if they want, they can actually mention that in the will as well. So that will avoid any sort of confusion in the future. Then the next one is the appointment of an executor. Normally, this is the format of our draft, our precedent. So that in India, I have looked at some precedents, and the appointment of the executor I have seen at the last. But here we will give importance to the appointment of the executor. So we will have the second paragraph as details of the executor. You should, as in the case of a first paragraph, even in the second paragraph also, you should have clearly mentioned who is the executor, his relationship, name, address, everything should be there so that he can be identified easily. And I have seen the precedents in India that only one executor is appointed in most of the time. But I think it is better to have more than one executor, because that will be helpful in future. If one of the executor predeceases the testator, then immediately the person has to go to the lawyer and make the amendments to the will. That may not be possible all the time. Or then the other situation is when if one of the executor changes his mind and he doesn't want to act as an executor, so you have an alternative person or option at the time, so the other person can initiate the administration process and all. And I always we should ask your client to take consent from the executor whether they are willing to act as an executor or not before putting their name in the will, because they may not be interested in taking a huge responsibility and all. Then next comes the bequest and all. You can set out all the bequest and all. And whenever you give a bequest to a person, be very careful. Be very careful about the words used, jointly, equal, and all. If the property is given to persons jointly, then all of surviving person will, if one of the beneficiary predeceases the testator, then other beneficiaries will be taking the property between themselves. But if you bequest the property to 2 or 3 persons equally, or in between 3 of them, then if one of the beneficiary predeceases the testator, then that beneficiary's 1/3 share or half share will be lapsed, and that will fall into the residuary clause. So you have to be very careful and take instruction from the client. If something happens to this beneficiary, what do you want to do with that asset? Do you want to give that to the children, or what to do? But in the case, because when I talked about the lapsing of the bequest, if a beneficiary is son or children, and they have their own children, then bequest to that particular son will not be lapsed. If the son has some children, that will go to the children. So that is the other exemption. If it is for a stranger or someone, if it bequest is given, and if he predeceases the testator, then that will lapse, and that will fall into the residuary clause. So residuary clause is the most important clause in a will, that should capture all the assets that have not been mentioned in the will, and that also should capture any bequest that may be lapsed in future. And even in the residuary clause also, if you are using the word in between or in equal share, you have to be very careful, because if that person predeceases the testator, that share will be lapsed, and then what happened, it is in the residuary clause, so that will go into the intestate succession, not into the testament. So then it will be a partial testamentary succession and partial intestate succession. So residuary clause is very careful, and that is why I use the word shall survive me. So you have to take instruction from the client what way you have to phrase that word, whether it should, if any one of these residuary beneficiaries predeceases the testator, what way you want to deal with that one. Then execution clause and all. So that is the format I have given. And in the next clause also I have given some formats, saying that formats of the clauses, how to draft the wills in the case of in the event of a decease of the beneficiary, to whom it shall be distributed, and all. I have just given some precedents. And then we'll just quickly go through the revocation of a will. A will can be revoked either by voluntary or involuntary. Voluntary revocation is when he actually revoked that will by writing in his will, or tearing it, or destroying the will. But all these should be done with the intention of revoking that will. If there is no intention, accidentally one will is destroyed or damaged, then it's not a revocation. So intention to revoke is there. And if someone is tearing the will, it should be with the instruction of the testator to tear that will or destroy that will. It will, without the instruction, you are not supposed to do that. Then the voluntary, involuntary will be the marriage. Will be involuntary revocation will be revoked on the marriage of a person. Even not only the first marriage, if he marries second marriage, if he goes for a second marriage, whatever will or whatever disposition, whatever will he has made before the second marriage will get revoked, and he has to write a new will. Then what's the okay? I think I'm running out of time. I'll just finish it up. Then how can you revive a will? A will can revive only by actually executing a new will or a codicil reviving that will. So that is also important. Then you have to look at the common mistakes that can come up in drafting a will. Maybe not specific about asset. I have seen the practice in India that people will be giving the details of all assets he is having to this, and including everything in the will. Here we don't normally ask the client to give us a list of assets while drafting the will. If he is giving specific bequest to some person, we will provide the details of that specific bequest in the will. Otherwise, if he is generally giving all the property to wife or children, then we will never ask that person to give the list of the assets, because it may be the assets will keep changing. He will be acquiring and disposing of the will, and if it's not going to affect the will, it's fine, because if that particular asset is disposed of, then that particular clause will be lapsed. That's all. But it may be a better idea to have a list of the assets as a codicil or as a separate sheet attached or pinned to the will, so that heirs will have an idea about the assets that deceased person is having at the time of death. So the deceased person can keep changing that list of the assets, rather than going to if he sold one property and he wants to, if he has given specific because of that property, definitely he has to make changes to the will if that property is sold. He has to. So there are certain circumstances a person has to be careful after drafting the will. If executor passed away, or if some of the beneficiary predecessors that tested, you have to make amendments to the will if you want to give someone else that share or not. And if the executor passed a predecessor tested, definitely he has to make an appointment. He has to amend the will and make a new executor for that will. Then the other mistakes are, some of the mistakes are interested parties as the witness. Never ever ask any beneficiary to sign the will. Then it will be an invalid will that can be contested by the court. Then if the beneficiaries are minors, definitely you should be appointing a guardian for the minor children. That's the most important thing. So I think I have covered most of the points. And the most important thing, I just as an advice to all of you, if you are taking instructions from your client, most important thing is to have an instruction sheet and get it filled by your client. And when you discuss the list instruction sheet with your client, get them to sign that instruction sheet. So because it will be produced as an evidence to show that that was the intention of the testator. And when you're consulting with your client for drafting the will, it should be done in private. Never ever take a beneficiary to that room while discussing the will with the client. And once you should communicate that your client or the testator with casual questions and all, just to test his capacity to understand the situation, whether he's of sound mind, whether he knows what he's writing, whether he can understand what he's doing, whether he's happy with giving whatever he give instructions are there, whether he's happy to give the chairs to that person, just to make sure that he's not doing it under undue influence of some beneficiary or not. So that's why I'm asking you to take the instructions in private. Let him relax and just have casual conversation to relax him and all. Then after leaving, after finishing the meeting with the client, just have an attendance note writing all these details to make sure, so that attendance note should also be attached to the will, to make sure that if this will is contested, this attendance sheet can also be a supporting evidence to show that the person was not under undue influence or he was of sound mind at that time. If it's a vulnerable person or something, it may be advisable to get medical evidence or something to confirm that he's of stable mind and all. So that's the other advice I can give to you. Then as I told you, it's a craft. So it all depends on each situation, how to draft the will, and it's the craftsmanship you are showing in drafting the will. So try to write the will to avoid all the mistakes and flaws, and to assure your client that this will never get contested in the court. So that should be your aim when you are drafting the will. Make sure that you are not making any mistake, and you are not putting your client into trouble, or you are not putting the administrators of the estate into trouble by making mistakes in the will. So that is my advice to everyone, and hope I finished it in time, or I don't know whether I got. Hope it's okay.
Yes, ma'am. Thanks a lot. That was a wonderful session, ma'am. ഭയങ്കര lengthy ആയിട്ടുള്ള ഒരു session in just 1 hour's time. You covered a lot of topics, and we really appreciate your efforts. Thank you very much, ma'am. Ma'am, now we have a few questions in our.
Okay.
We do have a few questions in our chat box. So, shall I read it to you, ma'am?
Maybe I don't know whether I can see it or not. Can I see it?
Yes, ma'am. You will be able to see it. Chat box.
Oh, okay. Yes.
Okay. We have a few questions in it.
You don't worry, ma'am. Tanya will read it to you one by one so that you can address each and every question.
Okay, the
Okay,
first question
ma'am.
I think is from Geeta Menon. If one of my children is
Yes, ma'am.
settled in US, how do I make a will as that country's tax law is applicable? Will it affect the will? Yeah, that's a question from one person. Is okay.
Ma'am.
So she's asking, one of my children is settled in US. How do I make a will as that country's tax law is applicable? Will it affect the will? So if you are an Indian resident and Indian domicile, and if you are writing a will for India, you don't have to worry about the inheritance tax in US, because you are giving the property, Indian property, to your son, who may have maybe a different habitual residence or different nationality. The property is situated in India, and as per Indian Succession Act, there is no inheritance tax. So that person won't be getting any. That is my advice, but they should definitely take accountant's advice on inheritance tax and all, because normally in Ireland we never advise on the tax thing to our client, because that's a totally different area confusing. But for my own purpose, when I made inquiries, I think inheritance tax is not applicable to children in India. And only thing, if you are bringing that money to UK, then you have to provide some evidence to the US and all, saying that you have paid the inheritance tax, or there's no inheritance tax in India, and you have to get it certified by the chartered accountant or someone in India and all. Then he can transfer the money to US if he wants. Otherwise, if the money is if the property is going to be in India and he's not selling the property and not changing that into cash, I don't think there will be any issue in that. He can you can give, you can write a will giving whatever share you want to that son. That's my, I think that is what she's asking.
Yes, ma'am. Yes, ma'am. Oh, and ma'am, another question is, how can we certify the will? This was from Rishabh Dilraj.
Certify the will in the sense, if you want to produce it into a foreign court, you have to certify it by a judge or a notary from India. Then it has to be apostille has to be impressed on that from the Department of Foreign Affairs in India. Then you can submit to the foreign court, foreign
Okay.
probate office or the court.
Okay, ma'am. Ma'am, another question from Anjali Nair is that, can a person file a will electronically?
What's the question? Sorry.
Can a person file a will electronically?
File a will means, what does it mean? I didn't understand.
I don't understand that. Anjali Nair, if you're here, you can actually ask ma'am the question. If not, we can move on to the next question, ma'am.
No,
Ma'am,
if you want to, if will has to be actually executed properly. So online, how can you execute the will? And if you want to submit that to some person for the registration or something, you have to check with the district of registration office to see whether it can be submitted online for the registration purpose. But for the execution purpose, a will cannot be done online. It has to be actually present between. Maybe in the COVID situation, I don't know whether online execution is acceptable or not. I don't think that will give validity to that will. It should be in a proper paper, and we normally we'll number the paper, and at the end of the last paper we'll say that this will is drafted in page number 1 to 4, and also it will make sure that there are only 4 pages or 5 pages for that will.
Okay, ma'am. Ma'am, she has asked another question as well. Do we require a will in case of intangible assets like copyrights and trademarks?
That copyrights and I don't think, because it's all a person to that one, and if somebody else is going to inherit that, right? Maybe I have to look at that one. I haven't looked into that aspect. I can look into that and I can let her know the answer.
Okay, ma'am. Ma'am, if you share it with us, we can send it to her.
Okay, that's perfect.
Okay. Ma'am, another question is from Vishnu. If you look into the chat box,
Yes.
you can see it.
Can a registered will be challenged by one of the beneficiaries? Yes, I one of the cases I have mentioned in my PPT is that one, even in the registered case, that they won't look at the formalities of that will while registering the will. Of course, registration will give authentication to that will, but they may not look at the form attestation clause and the form actually whether the will has actually complied with all the formalities of law or not, they won't look into that. When if you give a will to them, they will register it. So if the will is not properly attested or if it is not properly drafted, it can still be contested in the court of law. But only thing, registration will prove that that was the intention of the testator, even though there are some irregularities in the formalities of execution, that will be giving an authenticity to the document. So that's the only thing. Because one of the cases, if you look at, in that case, will is registered, but there was no executor appointed in the will. So that was contested in the court.
Okay, ma'am. Okay, ma'am. And during the session, Femi Anthony had asked a question. North Hall is an English case, and what is the situation in an Indian scenario?
Sorry, I didn't get very interesting
question.
information. What's
Yes.
that? I didn't get.
North Hall is an English case, and what
Yes,
about
it's
in an Indian scenario?
That's what I told you. That is in relation to joint accounts. So that most I think that can be relevant to India also, because I have my personal experience. If there is an account between father and, means in the joint names of father and daughter or someone, after death of father, definitely the account will be changed into the name of the daughter, and she will have the full right over that property, and bank is not going to ask about that. But actually, when you should ask the client what is his intention. If you have a joint account, what is your intention, whether you want the joint account holder to inherit that property or not, because it can be contested by the other people. There is no law in India which dictates that in the case of a joint account between father and daughter, the joint account holder daughter is entitled to the property. There's no law. I couldn't see anything. You can have it as your assignment. You can look into that law, but I haven't seen any law like that. So it is better for the testator to mention that in the will, that even though it is held in the joint names, this property should form part of the estate and it can be distributed as he wished. Or otherwise, he can say that this is held in the joint names of myself and my daughter, and after my death, she has full power and authority over that property. So that dispute won't arise after his death, whether that should form part of the estate or not, and that will avoid disputes between the heirs.
Okay, ma'am. Ma'am, one last question from Alan. What if the will is found long after the person's death? And if the properties are sold or passed, then what can be done?
So there is a presumption that if the will was in the possession of the testator and it is lost, it cannot be found, then there is a presumption that it is destroyed. But if it is appeared after a long time, there are difficulties. So make sure that if there is any doubt about that there was a will or something, make inquiries, and before distributing the assets and all, it is better to make a conclusion that whether that will has been revoked or destroyed by the testator intentionally or not. Otherwise, definitely that person can go to the court. That will end up in a dispute and will end up in the court for years, because if a will is found out after the distribution of estate, actually speaking, that transactions are void because they have no right to dispose of that property. So that will be a matter for the court to decide what to do, whether all that can be revoked or what. That will be litigation matter. So it is better to make inquiries to find whether the will is there, or try to find out whether the will is there before distributing or selling the property.
Okay, thanks a lot, ma'am. Ma'am, I think now we'll move on to the vote of thanks formal session. And we now come to the end of this beautiful session, and the duty is cast upon me now to deliver the vote of thanks. Let me begin by thanking our resource person, Solicitor Jaya Jayadev ma'am, for enlightening us on the intricacies of drafting wills, tips and traps. Ma'am, it was indeed a very informative session, and I'm sure all of us attending this webinar has benefited from it. Thanks a lot, ma'am. On behalf of the Srinarayana Law College family and the participants, I take this opportunity to thank you from the bottom of our hearts.
Hope this was helpful to all of you.
Yes, ma'am, definitely. I will be failing in my duty if I do not inform you that ma'am took a day off from her busy schedule just for us. And God bless you for that, ma'am. This has
Okay,
been
thank you.
surely a beneficial session. I also take this opportunity to thank our manager, sir, Sri Ajimon AR, for enabling this webinar. And I thank our principal, Professor Dr. Raghunathan KR, who was instrumental in bringing to our college innumerable webinars. And the most interesting of which was this international webinar. I now take this opportunity to also thank our coordinator, our very vibrant Ashwati Ujwal ma'am, for whose efforts have made this international webinar a huge success. I also thank the management, staff, faculty, and students of SNLC who have attended this session. Also, all of you participants from around the globe, without whom this would not have been a success. Last but not the least, I thank my fellow brothers, Siddharth Pisharadi and Ananda Krishnan, for being at my beck and call in arranging this webinar and for all the technical support rendered. Thank you all. Hope you have a good evening. And the feedback link will be put up in the chat box now. Kindly go to the chat box, fill up the feedback form. You will be receiving your certificates in 10 days' time. Have a good evening. Thank you.
Okay, thank you. Thanks a lot.
Thank you, ma'am.
Thank you. Bye.
Thank you, Jaya.
Thank you.